Please, Your Lordship. Let's giving Your Lordship's indulgence to mention a matter, Millet. So we have instructions to withdraw this pending criminal petition which is pending before this Honourable Court. Your Lordship's kindly permit it, Millet. There's some urgency because the cause of action on the basis of which this criminal petition had been filed and this Honourable Court had issued notice, that has been mitigated because the state has already written back to the bank authorities, Millet, on the basis of which the bank account has been made operational.
What criminal thing?
Millet.
No. Is it listed today?
It's not listed, my lords. I'm placing a mention memo, my lords, only for the purposes of withdrawing the criminal
Is
petition.
it before this court or before the...
It was before court 3, my lords, earlier.
Then
Only for withdrawal, my lords. We're not pressing on any other aspect of the matter. We want to withdraw the matter, my
no,
lords.
even then, see, I don't think it would be proper. Because that would again be, if there is no specific order by Chief Justice,
My lords.
then I don't think this court can take it up.
As your
What
lordship.
you can do is, the other court would be sitting on,
11th, my lords.
perhaps,
We will do that, my lords. We'll probably wait for another 10 days. My lords. Obliged.
so that it will not complicate matters.
My lords.
You can never tell.
Daily cost list, item number 1.
Lordship is the 438 application, Lordship. Lordship, in this case, Lordship, already 41A of the CRPC notice was served to me, Lordship. And in fact, the main fact is that, Lordship, in this case, FIR is on page number 9, Lordship. Some petroleum person, dealers, Lordship, they have lost this FIR, Lordship. And in this case, Lordship, one tanker was seized, Lordship, by the crime branch, Lordship. After that, Lordship, crime branch did a call to me, Lordship, and I appeared before the police station, Nampo, Lordship, and they taken my statement also there, Lordship. And that times, Lordship, I submitted my one salary, Lordship, that I have already purchased that very tanker to another person, Lordship. There is no any responsibility on me, Lordship. And on the same time, Lordship, they seized the documents, Lordship. Seizure list is on page number.
So the ownership was transferred prior to the date of the alleged incident,
Yes,
or is
Lordship.
it an ongoing, process of the
Yes,
alleged?
Lordship, I appear, but here, Lordship, for filing this bill application, Lordship, only that, Lordship, when I appeared before the police station, Lordship, without serving any notice, Lordship, they did a call, I appeared there, Lordship. After that, Lordship, I disclosed all the things, and Lordship, they, on the same date, by having the proof of the Lordship, they seized my mobile phone and the cell deed. Lordship, there's an annexure, Lordship, on page number. Lordship, on page number 14 to 19, Lordship, I have annexed this, Lordship. There is a seizure list with having a sale deed, Lordship. After that, Lordship, on the same date, they hand over me a notice, Lordship, 41A of the CRPC.
Notice under section 41A has been issued.
Yes, Lordship. After that, they
Once
hand.
the notice has been issued to you under 41A, there is no question of arrest.
Yes, Lordship. Now this comes on, Lordship. After that, Lordship, what happened, Lordship? I have appeared there, Lordship, on 29/11/2023, Lordship. When they did a call to me, I submitted all the things, Lordship. They recorded my statement also there, Lordship. They gave me a date to appear, Lordship, on 10/12, Lordship. But main thing is that, Lordship, on that very day, Lordship, I was not able to appear. Then also, Lordship, I sent the medical documents, Lordship, the IO concern. But things will start, Lordship. They started several times to visit my home, Lordship. After that, Lordship, on that day also, Lordship, when I reached without having any commission on the police station, whole day and whole night, they restrained me in the police station, Lordship. Now my simple prayer in this case, Lordship, I fully cooperate with the investigation agency. Already I am doing, Lordship. Now, Lordship, I appeared before the police station by having the interim production. After that, Lordship, call for the city, Lordship. Because here nothing is my role, Lordship. Only I am getting harassment from the police, only that to appear. I have already appeared. I have submitted all these things. Where is my role in this case? They harassment me, Lordship.
Again, I am repeating myself. Once a notice under section 41A is issued, there is no question of arrest until a report is filed before the concerned magistrate,
Yes, Lordship.
and in order is passed that he ought to be arrested. So yes, where's the apprehension now?
Lordship, yeah, I think the Lordship, I was appeared there in the police station on the same day. I was appeared there, Lordship. But the main thing is that, Lordship, there what happened, Lordship, if I am becoming a defaulter, I send the medical documents also here, Lordship. Annexed here, Lordship. Then also, Lordship, I am getting the threatening from that, Lordship. Only having a reason, I don't know. You should have to be appeared here, Lordship. Several times they visited my home also there, Lordship. If I am becoming defaulter, Lordship, in next notice should be served to me. Simply that, Lordship. But they want to know you should have to be appeared there. I have given the reason also there, Lordship. My simple thing is that, Lordship, I do not have any role, Lordship. Only interim should be granted in this case, Lordship. After that call for the CD, what is my role in this case, Lordship? Only interim I needed, Lordship.
He was called to appear on the 10th of 12, but he could not appear.
According to him, he had failed to appear on a particular date when he was sick.
He was not well, yes.
Yeah. Then why would you take advantage of that? Yeah. Would you threaten him with arrest because of that? The process has to go.
Yes.
Process under section 41E has to go.
Yes.
And there is no question of arrest. Until and unless you are very sure that he is to be arrested. Like I said, you know very well. Report has been filed before the magistrate concerned. Heard, Mr. Counsel. Mr. H. Harvey, additional PP, has appeared on behalf of the state respondent. The counsel for the petitioner has submitted that the police has issued a notice under section 41A in connection with crime branch PS case number 411/2023 under section paragraph 2. Accordingly, the petitioner had complied with the direction and had appeared before the IO. However, on a particular date, that is on 10/11/2023, he was not able to appear before the IO as he was not well, and thereafter the IO or rather the police had visited his house and has threatened that he will be arrested for non-compliance of the direction of the IO. Accordingly, being apprehensive of an imminent arrest, the petitioner has approached this court with this application, section 438 CRPC, seeking grant of pre-arrest bail. At this stage, since this court is not at this stage, the court is of the view that the case diary has to be produced to understand the complicity of the petitioner, if at all, and as such, the respondent, the state respondent is directed to produce the copy of the CD on the next date fix. In the meantime, as prayed for, the petitioner is directed is allowed to go on interim bail with condition that he shall not abscond or tamper with evidence and witnesses, and that he should report before the IO as and when required. As prayed for, list this matter on entering to 30th January.
I'm handing you
Produce
this.
the CD.
Item number 3.
May it please your lordship. My lord, here there's a misapplications also, my lord, and then today what I am is, my lord, praying for a status quo, my lord, till the pendency of this case, my lord. Here, my lord, I am aggrieved on two folds, my lord. Number one, rejection of my candidature to the post of state organizing Meghalaya Bharat Scouts and Guides, my lord. And there is no reason, there is no logic in rejecting my candidature, number one. Second is, my lord, a candidate who is suspected to have submitted, my lord, a forged or a manufactured documents, my lord, and in spite of bringing on record, in spite of bringing to the notice of the MPSC, my lord, yet such candidate was allowed to be selected, and now, my lord, the select list, the final list has come out. So on these two grounds, my lord. Now the first thing is, my lord,
See, Mr. Even I don't understand what is the urgency.
my lord, because the urgency is this, my lord. Once the appointment order is been given to the respondent number, the private respondents, my lord, and they joined, my lord, in spite of all these agitations that has been pending before the MPSC, my lord, then that would create more complications, my lord. Let the truth come out. Let there be an inquiry to the candidatures of to the private respondents, my lord. Uh, my lord, because then the inquiry proper inquiry needs to be conducted, my lord, in this. We have brought on record with proofs also, my lord. Now first point is this, my lord, why they have rejected.
You're agreed by the appointment of respondent number.
Respondent numbers are 4 and 5, my lord. 4 and 5,
There are two
the
posts.
private respondents, my lord.
Two posts.
Two posts, two candidates. Two posts, two candidates. All other candidates were disqualified, my lord. And my lord,
Both these candidates are also disqualified according to you.
uh, they should have been disqualified according to me, because number one, particularly the respondent number 4, is alleged of submitting a false or manufactured experience certificate, which the the officer concerned, the secretary, state secretary concerned, who purportedly issued under her seal signature, herself came and says that this is not a certificate I have issued. And this was also stated before the MPSC, my lord, saying that this is not a certificate I have issued against her. Now, the advertisement itself says, if any candidate is found to have submitted such a forged document, it will be debarred, my lord. Why this candidate was not treated? And whereas the candidate, my lord, myself, my lord, I was appointed as an assistant.
Yes, see, that is a process which will have to be looked into once the
Yes.
pleadings are placed before.
Yes, my lord, exactly, my lord. That is why, yes, my lord.
At this stage,
Yes, my lord. So only the status quo today, my lord. Let them bring on record. We will issue, we will give a fair chance to the private respondents as well, my lord. Let them come. Next year we can decide in the first instance
any
itself,
appointment
my
order
lord.
issued.
My lord.
Any appointment order issued.
Appointment order, my lord. They will be in a better position to say, my lord.
Department concerned, who is appearing?
All I am
And
saying.
what role has MPSC got to do here?
MPSC has conducted the selection process, my lords. We've given the recommendation to the department. We've had the select list prepared, my lords. We've given it to the department. It's now for the department to act on it and issue the appointment orders. Insofar as what my learned friend is submitting, my lords, regarding there being allegations of the experience certificate being forged and things like that, my lords, my instructions are that we conducted necessary inquiry. We did not find any anomaly in that, my lords. On the basis of that, the select list has been prepared and forwarded to the state.
Here.
Otherwise, also, my lords, there's one problem here because my learned friend's grievance seems to be with regard to respond number 4.
4.
Yeah, my lords. Respond number 5, there is no allegation per se against respond number 5. Yet, respond number 5 is also made a party, my lords.
Respondent number, my lord, the respondent number 5, my lord, has also submitted documents. Of course, there's no directly thing, but he has also submitted some documents, my lord, which, if the inquiry is committed, inquiry is conducted, my lord, by appointing a committee, my lord, it will come to light. Why? Because, my lord, we have proof, my lord, when there's a certificate of training in the national level, this particular candidate never went for a training in Nagaland. And the people from Nagaland, the chapter of Bharat Scouts and Guides, they are ready to vouch that this man has never come for training. How did he got a certificate issued in his favor, and that certificate was used to secure this job, my lord. So therefore, my lord, I would humbly say that status quo may be maintained. Let there be an inquiry, because, my lord, at the end of the day, this pertains to a public service where it has to be a very fair manner, my lord. And here the manner in which I was rejected, and the people who has got this kind of certificates gets selected, my lord. Therefore, my lord, we are before this court,
Mr. Yogin,
my lord.
even Mr. Karwanlang would say that, you see, at this point of time, we don't know what is the stage of the
Yes, my lord.
process.
Yes, my lord. Yes,
As far as the MPSC is concerned,
We've already issued the select list, my lord.
yes.
as far as their part is concerned, I don't think we have any, any quarrel on that, except for the fact that they have recommended some person whom, according to you, are not competent or not
My lord.
qualified. That will be looked into.
Yes, my lord. Yes.
But now, if at all, an appointment order has been issued
Yes, my lord.
to stay that appointment
My lord.
without hearing the person
Yes.
concerned,
Yes, my lord.
that would not be proper.
My lord. My lord, let them come with
In any case-
instructions.
in any case,
Yes.
Even if, let's put it this way, even if an appointment order has been issued and you agitate the matter, and in due course it transpired or it comes to light that they are not qualified, then nothing can be
Yes,
done.
yes.
What has been
That-
done.
Will finally
arrest-
strike it down, my lord.
That will
The
go,
court
my
will
lord.
take its
Yes, my
course.
lord. Yes,
I don't see any purpose
my lord.
of a status quo order here.
My lord. My lord, because that,
You take steps for issue of notice.
my lord, I'll take steps, my lord. Yes, my lord.
No
Yes,
interim measure.
yes.
Heard Mr. P. Owen, the counsel for the petitioner. Mr. K. Paul, learned senior counsel. Are you standing counsel?
My lords, for 1 and 2 minutes.
Learned senior standing counsel for the respondent 1 and 2 has appeared on their behalf. The respondent number 3 is also represented by Mr. A.H. Karwalang, learned additional senior PP, additional senior G. On prayer made by the counsel to the respondent for the petitioner, let notice be issued upon respondent 4 and 5. The same returnable within 2 weeks, within 4 weeks.
4 weeks, my lord.
The respondent 1, 2, and 3 in the meantime are allowed to file their counter affidavit within the next date fix. This is matter thereafter.
After vacation, my lord. Obliged, my lord.
Item number 4.
My lords, here we have not been able to serve notice upon the district council. My lords, yesterday somebody went to the district council. I think somebody even called my learned senior. So you will appear on the matter.
I just want to inform the court that we have not been served any copies
That's
of
what
the
that's
petition.
first thing I said. We've not been able to serve.
And,
The lordships may have this matter, my lords, after the vacations, my lords. We'll serve notice on the district council.
State has also not been served, my lord.
State has been
also
served.
not been
State has been served.
We have been back to, we have been looking.
Mr.
In any case, matter will
I think
be
Mr.
after vacation.
Mr.
The
Shulai,
additional advocate general has a copy of the petition.
No, just now we got it.
For R1 and 2, your lordship.
heard Mr. K. Paul, learned counsel for the learned senior counsel for the petitioner. The respondent number 1 and 2 are duly represented by Mr. N.D. Shulai, learned AG. However, the petitioner has made a prayer that he may be allowed to take steps for issue of notice on the respondents 3
Well, all the respondents, my lords, we'll take steps.
3 to 11.
3 to 11.
As prayed for, the same is allowed. Let notice be issued, the same returnable within 4 weeks. This is the matter after vacation.
My lords.
Lordship,
My lord, we have preliminary objection as to the maintainability of
No,
the
that
petition, my
you
lord.
see once that is done,
So then, Your Lordship, what I was saying that Your Lordship may not issue notice, let the copy be served, Your Lordship. Notice they have to give such primary facie case before Your Lordship. Then
What difference does it make? Well, there's an issue of question of notice. Your lordships have
therefore,
not
I was
admitted the
praying,
matter.
Lord.
See, once
I was praying, my Lord.
once notice we is issued, the matter will be posted for admission here.
Admission. Then your lordships will hear whether the matter is to. It has to cross
The
the
objection
threshold
is,
of
my Lord,
admission.
that my objection is that it is not maintainable for this.
It looks like
Writ
it, but
is not
anyway,
maintainable.
at this
Looks
stage,
like a heavyweight matter.
at this stage, the court cannot. Because the look, see,
Your
the-
lordships have not even.
because-
Your lordships have not even looked into the merits of the matter at this stage.
but
So that's why Your Lordship
prima facie, the
Lordship should not.
the locus of the petitioner has to be.
Lordships, that will have to be examined.
Lordship, in fact, I'd like to request my colleague to just give me one advance copy.
Yeah, he'll do that.
As a matter of fact, my lords, that's why somebody reached out to my learned senior yesterday if it could be done. We'll do that, my lords, after vacation.
Fine, after vacation.
Item number 5.
Please, Your Lordship. Please, Your Lordship. Lordship, in this matter, my lord, this is a company matter. Here, what has happened, my lord? The petitioner company participated in the tender process, my lord, and it was allotted the work of Shillong International Center for Performing Arts and Culture, in short, SICPAC, my lord. So, as per the tender agreement, my lord, as a security deposit, the petitioner company had to issue a bank guarantee, my lord, of 7 crores, which was done, my lord. And thereafter, my lord, the work was completed on 31st 12 of 2022. 31st 3, sorry, my lord. 31st 3 of 2022, my lord. And the project was also inaugurated by the Chief Minister, my lord. And now, because, my lord, the work has been completed, the defect liability period no longer survives, my lord. But to the utter shock and surprise of the petitioner, my lord, the respondent number 3 issued an impugned letter, my lord, which is at annexure 277. Annexure 50, page 277, my lord.
Yes.
Here it says, my lord, that it should be further extended for another period of 12 months. And that if the last paragraph, my lord, if lordship sees, in case the above request is not complied with, this letter may be treated as letter of invocation, and the proceed on encashment of the bank guarantee may please be remitted to the above by account pay demand draft in favor of Hindustan Steel Construction Limited. But this letter, impugned letter, is very much illegal, my lord, in view of the fact that the construction of work has already been completed, my lord. So, being aggrieved by this, my lord, I am before this honorable court not to give effect to this letter, my lord.
Yes, Mr. Shubhai. What is this? Who will submit?
Lord, what is being sought, my lord? What is being sought in this case, my lord, is the encashment of bank guarantee, my lord. And the law on this point, my lord, is that they have given performance bank guarantee, which has to be extended time to time. And this has to be extended because your lordship is aware of the law relating to bank guarantee. When bank guarantee, they have to extend the bank guarantee. It is a commercial terms, and they have come before your lordship in by way of writ petition, my lord. How this writ petition is maintainable when commercial terms, and they have to extend the performance bank guarantee only, because the purpose of performance bank guarantee, my lord, is to ensure that the building and everything is in order, my lord. And most important, my lord, if your lordship will see who is the relevant, who is the main party. The letter, impugned letter, my friend can place, because I have seen, my lord, impugned letter has been issued by Hindustan Steel Construction. They have not been served. Behind their back, they are trying to stay the encashment of bank guarantee, my lord. It is nothing but encashment of bank guarantee, my lord.
No, but my lord,
Yes, sir.
It is encashment of bank. It is a commercial terms, my lord. In writ, they are saying what is wrong in the writ petition in the commercial terms.
Yes.
When they have to extend, they should extend the performance bank guarantee. What are we asking for? Because today they want to succeed in the writ petition on very first day, saying that I do not want to extend the bank guarantee, my lord. Suppose tomorrow there is a defect in the
But that
performance center, my lord.
that would be covered by the defect liability period.
Lordship, Lordship, very much.
The defect, now what the point I was trying to make, my lord, is the defect liability period, because the entire contract has not been placed. What is the defect liability period? What they say, the defect liability period is over, my lord. Their statement before your lordship is defect liability period is over. But your lordship will have to look into the clauses of performance bank guarantee, because it goes beyond defect liability period. What is the period for which it has to be maintained, my lord? Time to time, in past also they have extended. Why did they extend when defect liability period
That has
was
been
over?
extended by us, my lord.
All these matters are, my lord, because what we are saying is that you extend the bank guarantee. What is, because your lordship may, I will have the entire petition, entire clause, because in these matters, my lord, I am covered by Delhi High Court judgment, recent judgment also, which says that in these matters, writ is also not maintainable, my lord. I can place that judgment also. My friend can place my judgment.
But meanwhile, it should not be given effect to, my lord. Why I'm saying
Why,
this?
if what they are saying,
Why I'm
what is
saying
their
this, my
prayer,
lord?
my lord? Prayer is that if there is a collapse of building tomorrow, then I will go and I will encash the bank guarantee, my lord.
Of course, that is logical.
And
That
that is commercial.
Then I'm
terms,
agreeing, my
my
lord. I'm agreeing. I'm not disputing to that, my lord. But once the defect liability period is over, my lord, they cannot extend, and that too, I have to extend the defect bank guarantee. It should not be from them, my lord. It should not from the other side, my lord. In fact, if defect liability period only survives when the construction of work is not yet completed, but it has been completed, it has been inaugurated, my lord. I can show you the annexures, my lord. Kindly come to page 269.
Beyond the period of
Annexure 10,
construction
my lord.
also.
Annexure
Let
10.
them show the clause where the performance bank guarantee cannot be extended in the contract. What they are only making the submission that
Lordship,
it is
kindly come
confined
to
both avenues. Oh, I will go and inaugurate the building.
Lordship.
But there are parts of the building which are not complete, my lord.
Mr. Kumar.
So therefore, this is a purely simple commercial terms in which they are saying that the court should stay the extension of performance bank guarantee, my lord, because when this is a clause where it is in the public interest that they should extend. What is the harm in extending? And I will file it.
Tell me, Mr. Kumar, when will the contract or the terms of the contract expire? Isn't it after the completion of the project?
Your lordship, there are certain. Let my friend place performance bank guarantee before your lordship. Has he placed performance bank guarantee? What does it say, my lord? Because I don't have the copy of performance bank guarantee. Let him show from performance bank guarantee that it is limited to this only. And how this is a commercial. There is a commercial terms, my lord. What my friend is trying to go into this is in commercial matters.
8, my lord, page 259. That has been extended by us, my lord.
What?
Because the work was not completed at that point of time. That's why we extended the bank guarantee, my lord.
Will your lordship kindly see the terms, my lord? 245. I have got it. The contractor shall be governed by general conditions of contract of CPWD, special condition of. I am reading 201, my lord.
Just a moment.
Lordship, I am reading very slowly. The contract shall be governed by general conditions of contract of CPWD. My lord, they have not placed what is the general special conditions of contract.
We have placed. My lord.
The work specified in the tender shall be governed by tender form 7 for the percentage rate. Now your lordship, name of the work your lordship will see. The construction of Chilaun International Center for Performing Art, an estimated cost of 129.13 crore only approximately. Contractor has to report his earnest money of.
You are reading.
Value of the contract and what the performance security of contract from any nationalized bank submitted within 15 days shall be valid in the defect liability period. Now, kindly see the defect liability period. Where is the defect liability period? My friend can point out. It is nothing to do with the construction. It is with the defect liability period. And my friend is not talking about defect liability period. He's saying I have constructed, that is fine.
I'm saying defect liability period no longer survives.
What is the clause of defect liability period? Please show you have to argue the case. I can't defend my case because you are not placing my construction is over. Therefore, I'm entitled to refund of performance bank guarantee. Contract says it has to be up to defect liability period. What is the defect liability period?
Lordship, can we come to page 168, my lord? This is the general condition of contract, my lord.
The defect liability period will be in the contract, my lord. It will be in this annexure 8, my lord.
Should be there.
Yeah, this is the general condition of contract.
They have not placed it, my lord. They have not placed
Page
it.
168, my lord.
Excuse me.
I don't have the copy of
This is release of the security deposit, my lord. Clause 45.
This is
One
not
page
security.
is
Performance bank guarantee is different from security deposit. Please show the performance bank guarantee which is linked to the defect performance bank guarantee.
Let me just.
Clause
45, my lord.
I don't have the copy. I have not been served with the copy.
Mr. Shulai will have a copy.
They have the copy, my lord. He's out of station, so. Lordship, release of security deposit of the work shall not be refunded till the contract producer clearance deposit of the labor certificate from the labor office. As soon as the work is virtually completed, the contractor shall apply for the clearance certificate of the labor officer under intimation of the engineer in charge. The engineer in charge, on receipt of the said communication, shall write to the labor officer to intimate.
Just a moment.
I'm sorry.
Please continue.
To intimate if any complaint is pending against the contractor in respect of the work. Even perform the defect liability period also when any.
The defect liability period will run from which date?
From the date, my lord, when the labor officer, my lord, they do not submit any complaint, my lord.
Yes.
Defect liability period is when from the department, my lord, they say that there is a defect. Then the defect liability period will also.
Defect liability period is not like that.
The defect liability period is not like that. It is. See, let's assume it. See,
Lordship.
that the project is completed on a certain date.
Lordship.
So the defect liability period will run from that day
Lordship.
to a certain period.
Lordship.
Could be 6 months, 12 months. Or
Lordship.
whatever.
Lordship. I do agree, my lord.
It could be stipulated in the contract or
Lordship.
could be general principles. You see. So within that period, if there is no complaint by the
Lordship.
labor officer, whoever, then
That is what I'm trying to say, my lord. There has been no complaint whatsoever from the department, my lord. And even there is no complaint from the department whatsoever, my lord. And even the bank guarantee has to be extended from our end, my lord. From our end.
Performance bank.
There has to be from our end, not from their end, my lord.
259, your lordship, kindly see 259.
yes.
This is the performance bank guarantee, my lord. And your lordship will see clause 8.
Yes.
The guarantee shall continue and hold good until it is released by director Shillong on application of the contractor after experience of relative guarantee period. My lord, kindly mark. Of the said contract, and after contractor has discharged all their obligations under the said contract and produce a certificate from director Shillong representative certifying the due completion of work under the said contract and no demand certificate provided, always that unless extended this guarantee shall remain in force till 26. Should it be necessary to extend this guarantee beyond the said date on account of extension being granted by director or to the contractor in completion of work under said contract or otherwise, we undertake, my lord. Your lordship, kindly appreciate, my lord, that they have been extending this bank guarantee time to time because there was no completion certificate, there was no extension, my lord. And therefore, in these matters, my lord, this is the bank guarantee. I mean, bank guarantee law is very clear. What they are saying is that, look, I do not want to. They want to succeed in the writ petition today only, my lord. They do. I will file reply, my lord. I am not saying, your lordship may not issue. I will file first. Writ in these matters are not maintainable.
Lordship.
Second, the bank
Lordship,
guarantee
kindly come to page 272, my lord.
They have been extending bank guarantee, my lord.
272, my
lord.
Yes, but you see, they have been extending, no doubt. But now
Kindly
you're
come
saying that it's a different entity which has.
We are saying defect liability period no longer survives, my lord. That is our case. Now, kindly come to two.
We are saying that I have done my work and therefore.
Both of you are submitting at the same time. What can I?
question was put to me, Milord. Question was put to me. My friend was question was put to me. What I was trying to say,
Let us
see,
say what it
Milord.
is.
Lord will see. Kindly see page 265 also.
Yes.
These terms, Milord, your Lordship will see time to time they have extended.
And who has got it extended?
By the petitioner only, Milord.
That is what exactly, my lord. That is my
What
case,
they are
my lord.
saying is,
That is
I
his
don't.
case.
That is my case, my lord.
Please allow me to argue. Because then you will argue with my friend.
Yes.
Because then we both can't argue together. Na? See, kindly see, Milord, 265, Milord, 265. What is being said before your lordship is this, that my work is over, completed, inaugurated, therefore defect liability period is over. What my friend is arguing before your lordship is this much only, my lord. And therefore I am not liable to extend it. That is what they are trying to say. My lord, they have not placed before your lordship the defect liability period, clause relating to defect liability. What they are trying to show is the refund of security deposit. Second argument which I have, my lord, is that if the period performed, they said that we have completed and inaugurated long time back. After the completion and inauguration, what was the need and occasion for them to extend it, my lord? They extended that, therefore they extended that they knew that defect liability period is yet not over. So therefore, my lord, and in these commercial matters, my lord, I am not saying your lordship may not look into the clauses. What is their prayer as on today is that please grant me the whole relief by staying the extension, my letter. Letter is basically, if the letter is stayed, my lord, then they will not be required to let them extend the bank guarantee for 1 month. I will file or one. I'm not saying extend it for 6 months. I let them extend, let the bank guarantee be alive, because once the stay is there, bank guarantee will lapse, and they will succeed. So in order to balance the equity in favor of petitioner also and in my favor also, my lord, both the public favor also, my lord, let the bank guarantee remain alive during the, because in all writ matters, my lord, I have seen, or commercial matter, what I have seen from my experience, that the bank guarantee is kept alive during the process, because once there is a stay, bank guarantee will lapse, my lord. Bank will not renew it. Ultimately, if it is found that no, they are bound by to extend the bank guarantee, my lord. Even because if their whole argument is that my bank guarantee, after completion, I was not required to extend the bank guarantee. And your lordship is aware, my lord, that after performance is over, defect is only for 2 to 3 years. If there is a structural defect or latent defect, in all CPWD matter, my lord, performance bank guarantee is not only linked to the completion plan, but also to the defect, because it is related to defect, my lord. So defect, that is why, my lord, it is there.
That is understandable. That is understandable. See, the only concern is, you see, it will cover, like you just a while ago you said, it will cover either for a period of 1 year or 2 years or 3 years. See, that has to be specified.
Yes.
That has to be specified in the general terms of the contract or specifically elsewhere.
Yes, Lordship. Yes, Lordship. So your Lordship is right. What I was trying to emphasize, my Lord, is that what they are saying is that my performance is over and therefore I am not liable to extend it, my lord. My case is that it is a defect liability period. It is not linked purely to the performance. It is linked to the defect in the workmanship. Because sometimes latent defects are discovered after a certain period of time. And that is why in all engineering contract, my lord, because if it is discovered after some time, my lord, so then in that case, this kind of difficulty may arise, my lord. And they have been extending the bank guarantee time to time, knowing fully well that my case is that if it is linked to performance only, why did they extend it? Because they know that it's not linked to performance, it is linked to defect liability period, as a clause 8 of the performance bank guarantee I have shown, my lord. It is related to defect liability period, and what they are trying to show is return of security.
Mr. Kumar, you should also understand that the contractor has been given a certain project to do. He has done it.
Yes.
He has completed it. According to him, it has been handed over. Now, you cannot have a contingency plan by way of holding on to the bank guarantee.
I am not, my lord. Kindly take note of this fact, my lord. I am not holding it. performance bank guarantee means what, my lord? And defect liability period, I put a question to myself. Am I holding the bank guarantee? I'm not, because they are bound to furnish the bank guarantee. Why will I hold it when it is not of any use, my lord? Because I will hold it. Kindly see the terms. Let me see the performance bank guarantee. Your lordship feels that I am hold. Why? Because they are saying they are coming to the court. My performance is over, and therefore I am not entitled. So this bank guarantee should have been expired in 2018 as per the original terms. Kindly see page 259, my lord. There has to be some equity, because this is. They will come in the court and they will say that my book is over, and therefore your lordship is stayed. Your lordship is stayed. What do I do? Because if this is the 259, your lordship, the reading of the code, what can I do? I can't do anything. The performance bank guarantee. Can you see the clauses? I will read one by one. In consideration of director, first line, art and culture, Shillong, Meghalaya, having office and so and so. Kindly see, this is the accepted by contractor, resulting in what is the contract value, my lord? 151 crore 32 lakh 65,000 rupees. I have paid him 151 crore rupees, my lord, and they are not complaining. Now we, the Canara Bank, who is the bank is necessary party in all these bank guarantee matters, my lord. Whether bank has been served, the order has been issued by Hindustan Steel. This is my, have they been served, my lord? In absence, they are trying to take advantage of the order. Have they been served, my lord? We Canara Bank, a body incorporated under who is giving the guarantee? Bank, my lord. And in the bank, my lord, I will place that Delhi High Court judgment also. We, the Canara Bank Prime Corporate Branch, undertake not to revoke the guarantee during its currency without previous consent of Director Shillong, and further agree that guarantee herein shall continue to enforce till the Director Shillong discharges his guarantee. So Canara Bank is giving guarantee to me, lord, at their behest, and it is. Kindly see, and this has been extended time to time.
Yes. That's apparent.
So this bank guarantee is a document between bank and director. The guarantee shall continue and hold good unless it is released by director. Did I release it, my lord? What they are asking for? Direction from the court to release the bank guarantee. On application of contractor after expiry of relative guarantee period of the said contract, and after contractor discharge or obligation under the said contract, and produce a certificate from director, Shillong representative certifying the due completion of work under the said contract, and submitted no demand certificate provided always under. Where is the no demand certificate they have submitted, my lord? Let them show no demand certificate, my lord, under the contract. Necessary till so and so. In respect of completion of work under the said otherwise, my lord, we undertake to extend the forthwith period of guarantee on director request till such time as may be required by director. This is the guarantee bank is giving. I will extend it, and my letter which they are asking that they will stay is the letter. I am writing a letter to bank to extend it. We Canara Bank Prime Corporate shall be discharged of our liability under this guarantee unless a claim made by director within 3 months from the date of expiry of bank guarantee. I have made that request, my lord. Shall be effected only when BG is transmitted through. This is the one aspect matter. Then your lordship will see the government of Meghalaya, they are extending it. Canara Bank is extending it, my lord. Canara Bank is extending it time to time, my lord, because there is no certificate, there is no completion. So certificate. So where in these commercial terms, my lord, what they are saying, my work is over, therefore I don't want to extend the bank guarantee. That is what they are trying to argue before the law. And kindly see Delhi High Court judgment on this.
Where is the no demand certificate?
They have not issued, my lord. That is my. I'll come to that. Let him submit first, my lord. I'll come to that, my lord. Or else you may say that I'm interrupting, my lord.
Yes. Please continue, Mr. Kumar.
Yes, Lordship, kindly see the judgment of the Honorable Delhi High Court on similar issue, my lord. Is 2023. My friend has placed that copy of the order. Kindly see. The instant arises from the judgment of 9/4/20 passed in writ petition, where the learned single judge dismissed the writ petition and held that appellant herein cannot invoke the extraordinary writ jurisdiction of High Court under 226 of Constitution of India, and dispute arising out between the parties ought to resolve through the Contract Act in accordance with inappropriate sealed proceeding before the appropriate court. Sworn of details of the fact necessary for adjudication of present dispute are as under. On 21st July 2017, respondent corporation floated a tender bearing number so and so, invited bids from interested party to collect toll and environment compensation charge from the specified commercial vehicle so and so. Appellant submitted a bid and was declared a successful bidder, my lord. Thereafter, appellant and respondent corporation entered into the agreement. It is 4, my lord. It is stated as per terms of the contract, the appellant was entitled to collect penalty in a specified commercial vehicle evading toll. On these are the, my lord, I am just coming to the bank guarantee part of this. Now, 11, my lord. On 18/11/2000, recommendation of the high-level committee were pending consideration and the deposit was demanded, my lord. Payment was demanded. And then their prayer, my lord, is that Roman 17, my lord, Roman 17 of the judgment. Challenging the order of 31st January to 2020 and the demand notice dated 14/2, appellant filed the underlying writ petition on 19 February 2020, praying inter alia, issue or any appropriate writ, appoint independent adjudicator to adjudicate claim of issue of declaratory writ in effect the clause 16 of the agreement, which provides for adjudication mechanism, is been left unworkable on account of inaction of the SDM commissioner. So various writs have been fresh assessment, my lord. They question that also, my lord. Now, a lordship will skip the factual part. I have already shown, my lord. Kindly come to page, my lord. Kindly come to page 4, my lord. The relevant part I'll kindly argument is paragraph 3, my lord. Paragraph 3 of the judgment. Dushyant Dave, learned senior counsel appearing for the appellant at the outset submitted that present dispute between the appellant and South Delhi of contract executed between parties on 28/9/2017. He has submitted the respondent corporation has been created under the Corporation Act and is therefore amenable to extraordinary jurisdiction under Article 226 of the Constitution of India. It is the submission that learned single judge has made error in dismissing the writ petition and holding that writ petition is not maintainable when the present case is one ought to be adjudicated by Constitutional Court in exercise of it. Mr. Dave submitted that appellant herein had on multiple occasions requested respondent to appoint independent adjudicator for claim law. After, my lord, paragraph 6, my lord, where Mr. Dave has relied on certain judgment, Mr. Dave has placed heavy reliance upon the decision of Honorable Supreme Court in Radhakrishna Industries and so as to submit that exercise of alternative remedy is not a bar on the High Court in exercise of jurisdiction under 226 of the Constitution. He submits that there are 3 exceptions to the rule of bar on exercise of writ jurisdiction when there is an alternate remedy, which is first, when the writ petition has been filed for the enforcement of fundamental right. Second, when there has been a violation of principle of natural justice. And third, when the order of the proceeding is wholly without jurisdiction or the virus of the act. It is submitted by Mr. Dave that writ petition filed by appellant was maintainable and there is a violation of principle which is ground for permitting so and so. These are the arguments, my lord, of Mr. Dave. But basically, argument, then paragraph 13, my lord, contra argument. For contra, Mr. Sanjay Vasishtha, standing on
Where's the reference of a bank guarantee here?
Your lordship, what my lordship kindly see paragraph 22 onwards. What the point I am trying to say, it is a commercial matter. In commercial matter, bank guarantee is part of the contract only, which the bid was submitted. It is in that context only the judgment has been rendered, my lord. Paragraph 22. The traditional view, paragraph 22, view has been taken in the contractual matter between state and private.
Mr. Kumar, what you are trying to say is an issue of jurisdiction.
Yes, your lordship. I'm trying to first raise the issue of jurisdiction by saying that this bank guarantee has been submitted pursuant to the contract entered into between the parties, my lord. In the contract itself, there is a provision for arbitration, my lord. There is a provision for arbitration. The contract, in terms of contract, your lordship has seen that the certificate has to be issued by director, arts and culture. My friend has said that no certificate has been issued. Has he sought, because the condition precedent for extension of bank guarantee, that certificate, if you till the time certificate is not issued, my lord, that bank guarantee has to be extended. You have entered into the contract. When you signed the contract, when you got it 155 crore rupees, you entered the terms with your open eyes, my lord. Now, what we are saying is that because your performance defect is not over. We may have number of defects, my lord. Suppose I find the defects, then I will recover, because from that money only I will get a contract. As on today, they have been extending it, my lord. and they have been extending in terms of contract, and they have come to the writ court. They could have gone. What the prayer, your lordship will see. What they are not saying that, because first prayer is that there has to be direction to the director, art and culture, to issue completion certificate in terms of the contract. That is not their prayer, Milo. That is not the period. And therefore, this period is not yet over. What I am trying to say is that period is not yet over, and bank guarantee, they cannot seek a stay in this manner. What they have to, what they are saying that status quo means I will not be able to use the bank guarantee, my lord, and they will not keep the bank guarantee alive. I have no issue, my lord, if your lordship is inclined to entertain or see. Let them keep the bank guarantee alive during the pendency of the writ petition, my lord, and we will not encash it till the matter is decided. I am trying to balance the equity in both sides.
That would be fair.
Lordship, if status quo is maintained, my lord, I have no grievance, my lord.
Status
Because
quo
it should
means
not be
that they
encashed,
will
my
not-
lord, and it should not be extended also, my lord.
Let them keep the bank guarantee alive, my lord. Let them keep
Let
the bank
status quo be
guarantee
maintained, my lord. If let status quo be maintained, my lord.
Bank guarantee
It
will
should
be
not be
over by
extended,
31st
no.
December.
Lordship.
See, what
That is not
what
fair.
Mr. Kumar has submitted is perfectly, logical.
Lordship.
In a sense that the bank guarantee will be in force or will be extended to a certain period,
Lordship.
wherein after, in the meantime, the matter will, will proceed.
Lordship.
You'll be able to state your case.
Lordship.
They'll be able to state their case.
Lordship.
And at the end of the day, when the matter is resolved, then the matter ends there.
Lordship. But my
What has been submitted is also, logical. See, equity has to be balanced. But this
No,
essentially is a
my
contractual,
only
this
fear-
essentially is a contractual issue. This court could not have entertained such a petition unless there is a flaw in the process.
Lordship. Lordship, my only fear is that if they encash it, my lord,
Now,
or
they have
if the statements can be recorded, my lord, it should not be extended.
commitment has been given. There will be no encashment of it.
Petitioner will extend the bank guarantee, my lord. Petitioner will keep the bank guarantee alive during the pendency of the writ petition. The lordship may hear the matter
Extension
finally
of
at
bank
the
guarantee, my lord,
opening.
let status quo be maintained, my lord. Because
They are not trying.
I'm not saying that it should be extended also, my lord. But why I'm saying this, my lord? Because lordship, so far as jurisdiction is concerned, my lord, lordship has very much having jurisdiction, my lord, as per the contract agreement itself. Because there is no arbitration. Para 18 says so, my lord. Para 18 says so of the contract agreement itself. It says that in the event of any dispute or difference whatsoever arising out of this agreement or in connection therewith, including any question relating to meaning and interpretation of this agreement or any alleged breach thereof, the same shall be settled as far as possible by mutual discussion and consultation between the parties of this agreement. In the event of such disputes or differences not being settled in a aforesaid manner, the dispute shall be referred to the court of law having jurisdiction in Shillong and not through arbitration.
Exactly.
So that will go to civil court.
That is a civil court.
But my prayer, my lord, is that it should not be given effect to, my lord, to that extent.
Fine. That is, they have committed. They will not do it.
But they have to keep the bank guarantee alive, my lord.
Yes,
That
it has
is
to.
during the pendency of
Bank
the
guarantee will
petition.
be.
That
Will have to.
that order has to come, my lord, because they will not keep the bank guarantee alive. I know them.
Nobody can take advantage of the situation.
No, the moment again the bank guarantee, my lord, why I'm saying this, my lord, because it's 7 crores, my lord, and unnecessary we have to pay for the
And they have
interest
received
and all, my lord.
160 crore rupees, my lord, from us.
And
160 crore rupees and 7 crore rupees.
It's a matter of 1 month.
lordship,
Matter of 1 month.
it's expiring 31st 12th, my lord. That is the reason why, my lord, what the contents of the letter impugned herein, it says that if it is not extended, then only, my lord, it will be encashed, my lord.
Please extend it by 1 month only. I'm not saying that you during the, as long as it is, they want to succeed on the very first day without showing that they are not. So let them extend it for the period when the writ is pending, my lord. I will show that writ is not maintainable and we are entitled to encash it also.
Fine.
Lordship, here I just want to bring to the notice of this honorable court, my lord. There's some error which has crept in, my lord. Here, the petitioner's company is actually NCC. It was a former name is Nagarjun Construction Company Limited, my lord. But here, due to oversight, my lord, we have given the full name. It's no longer Nagarjun, my lord. It's only NCC Limited. So if it can be read only as NCC, my lord, meanwhile we'll just correct the
But NCC,
NCC Limited
This is
only.
not,
what does NCC mean?
my lord,
No,
this is
it's the company name only, my
defect in
lord.
the
NCC Company Limited.
serious defect.
It's NCC Limited only,
The
my lord.
company system which has filed the petition, my lord.
It's NCC Limited only, my lord. So meanwhile we'll just
Nagar-
correct the cost title, my lord. It has already come up in the pleading, but due to oversight, my lord, we just gave as Nagarjun, my lord. If that can be corrected, my lord, I'm just seeking the indulgence, my lord.
No, my lord, the lordship will see in paragraph 1 also it is Nagarjuna Construction Limited.
It's
only.
formally,
friend
my
is-
lord. Formally as Nagarjun, my lord.
Even in the affidavit also, your lordship, at page 24. Come to page 24, your lordship.
No, that is my prayer, my lord. Instead of Nagarjun, my lord, because we have also written NCC, my lord. It can be just read as NCC Limited, my lord. Meanwhile, just correct.
What difference does it make?
No, the difference is, my lord,
Because we not-
this is a different entity now, my lord. It's a different
Petitioner
entity,
is
my
not
lord.
in existence, my lord.
It's a different
Petitioner is
entity,
not
my
in
lord.
existence.
No, but the
No, this
Petitioner
is the
not in
company's name
existence.
only, my lord. NCC. Former, it was Nagarjun. It was Nagarjun Construction Company Limited. But now it is only NCC Limited, my lord.
doesn't matter. You see, here in your agreement also, see, look at page 35. Your agreement, so you have clearly indicated that it is formally.
Yes, formally, my lord. It was formally, yes.
So,
No, but the problem would arise later on, my lord. That is why I'm just seeking the indulgence of this honorable court. If I may be allowed to just,
those are technical.
yes. We'll
They
just
have to
scrap
file
off.
correct memo parties. They have to file amended memo parties, my lord.
They have to do that.
Yeah, we'll serve them copy, my lord. The correction petition will provide them, my lord.
Where is
The
the
copy, it has to be in the record of the court.
where is the impugn?
Impugn letter, my lord. Impugn letter. Impugn letter is 11/12/2020, page 277, my lord.
277. Art Mr. G. Moon, Learned Counsel for the petitioner company, who at the outset has submitted that there is a defect in the cause title of this petition, inasmuch as the name of the petitioner is noted as Mrs. Nagarjun Construction Company Limited, under bracket NCC.
No, it should be NCC only, my lord.
But here you have
Yes, my lord. My apologies.
when actually the entity is now simply named as NCC capital,
Limited.
no? NCC
Limited, my lord.
Limited. It is prayed that whenever such defect appears in the petition, the same may be allowed to be rectified. On premiere, the memo of rectification is allowed to be filed before this court. The Legal Counsel has further submitted that the petitioner is aggrieved by a communication dated 11/12/2023 issued upon the senior manager, Canara Bank, Prime Corporate Branch, BR capital TSR Complex, Sadar, Sadar Patel Road, Hyderabad, Telangana, wherein a request has been made for extension of bank guarantee number I can quote the amount to 277 dated to of rupees. It is the contention of the Learned Counsel for the petitioner that the concerned project has since been earlier known as
Shillong Integrated or Shillong International Center for Performing Arts and Culture.
under bracket I SIC Park,
Yeah.
now known as
Lariti Performing Center.
Lariti Capital Performing Center has since been completed, and the same was you have handed over to the
Yes, we have handed over, my
same
lord.
was handed over to the government of Meghalaya and the Arts and Culture Department,
Lodge.
and the same was also duly inaugurated. When was it inaugurated?
Inaugurated was 14 November 2022. 14/11/2022.
11/2022. In this connection, where is that term you're calling defect? Mr. Movin, you
Lordship.
This will be at Milord 260. This will be clause 8, Milord. That is page 260. Clause 260. Page 260, Milord. Clause 8.
no, we're talking about the defect liability period, no?
Defect liability period.
8 also says, Milord. Discharge all their obligation under the said contract and produce a certificate from certifying due completion of work under the said contract and submitted a no demand certificate provided all this. These are the requirements, my lord.
Oh, of course. No, 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 the defect liability period has since expired, and accordingly there is no requirement for the said bank guarantee to be extended, as was done by the impugn communication, as has been paid for in the impugn communication.
My contention is not defect liability period is not over.
No, that's I'll note down your intention. Don't worry. It is therefore prayed that during pendency of this writ petition, this said communication dated 11/12/2023 may be stayed. Per contra, Mr. E. Kumar, Leonard E.G. has submitted that the first objection raised in this proceeding is to the maintainability of this petition. since the issue involved here involves here is with regard to a contract, agreement and the conditions thereof, and as such in view of the principles, in view of well-stated principles of law, the matter ought to have been agitated before a competent civil court. Be that as it may, it would be incumbent upon the petitioner to satisfy this court that a petition would lie before this court invoking the extraordinary jurisdiction under Article 226 of the Constitution. The learned AG has also led this court to the terms of the performing bank guarantee which was annexed in this petition as Annexure 8, page 259. Page 259 or page 261? There are two page marking here.
Make home. 259. Performance guarantees 259.
259.
Annex 8.
Particularly at clause 8 of the same, wherein it is an obligation on the part of the additional contractor, additional oblique contractor,
And bank also, Mila.
to discharge all their obligation under the contract, and for the Director, Arts and Culture, Director Arts and Culture is respondent number. Have you made him respondent? Director Arts and Culture?
Respond number 2.
Respondent number 2 to issue a no demand certificate as far as the said bank guarantee is concerned. It is also the contention of the learned AG that the defect liability period has not yet expired. However,
Not the certificate has been issued by the Director Arts and Culture, Mila.
that has been noted.
Yes.
However, at this juncture, the learned AG has submitted that this petition may be heard, that this petition may be allowed.
My preliminary objection may kindly be heard.
Yeah,
First,
that is all. That is
because the writ petition will go in merit also, my lord. My first is they have to cross the preliminary objection threshold. Then only your lordship may go into the merit issue.
that this petition may be posted for admission hearing particularly on the issue of maintainability of the same.
Obliged.
In the meantime, as far as the extension of the said bank guarantee is concerned, the landed AG would submit that the same may be allowed to be extended only for a period of 1 month.
During the pendency of writ petition, Your Lordship, during the pendency of the
During
writ
the
petition.
pendency of this
Writ petition until such and further orders of this court, my lord. Because after the writ is dismissed, they will say that till further orders of this court, my lord.
during petition, during the pendency of this, and or until further order of this court. It is also the assurance on the part of the respondent, state respondent, that the said bank guarantee will not be in cash during such period.
Yeah, Your Lordship, may also record the statement of the petitioner that they will extend the bank guarantee, because the bank guarantee has to be extended by bank. Bank is not party to this case, my lord. And that therefore the letter has gone to the letter has gone to the bank. Letter has gone to the bank and they have not been served. So what petitioners should do before Your Lordship, that they undertake to extend the bank guarantee, my lord. That undertaking has to be there. My statement is that this should be extended is one, and it is for them to extend it, my lord.
That's what they have been saying all along.
No, but the statement has to be recorded in the order, Your Lordship. The statement is not recorded in the order. Their contention is recorded that defect liability period is over, but their statement is that they will extend the bank guarantee is not there, my lord, because somebody has to extend it, my lord. Should be extended is my submission, my lord, and on that, let the petitioner say that we will extend the bank guarantee during the petition, my lord. So that if they do not extend it, I have a remedy to come before Your Lordship.
In the meantime, as aforesaid, the petitioner may be allowed to get the said bank guarantee extended for such period as aforesaid.
Till a month, my lord.
Let's hope the matter, is resolved within a month. Because the moment the matter is taken up on board,
Lordship.
with all the parties, in attendance, then it will be resolved. Because initially it will be the issue of maintainability.
Lordship.
Once you cross that hurdle, there is no. I don't think there'll be any more litigation on this.
Lordship.
It will not extend. On consideration of the submission made, this court is of the considered view that the submission made by the parties at this point of time be allowed. Accordingly, the petitioner, apart from its assurance that the defect as stated be corrected, notice may also be issued upon the respondent number 3, 4, 5 and 6.
6 is the bank, my lord.
Respondent number 3, 4, 5 and 6, comma, as stated, the respondent number 1 and 2 being duly represented today, for which no formal notice is required to be issued. The petitioner shall ensure that the said bank guarantee is extended for the relevant period in course of these proceedings, and the assurance of the respondent that the same shall not be encashed is also noted on record. in the meantime, the respondents are allowed to file the response to this petition within the next date fix. This matter immediately after the vacation, after the court reopens.
After the vacation.
On conclusion of the after the vacation.
So one small submission, Milord. Let them file the extended bank guarantee before this court, because we do not have the document, Milord. Because if they have, they will extend it. Let them observe a copy of extended bank guarantee on this.
That they will do it because the order is already there. If they
So
don't comply with the
then
order,
because
if they
we
don't
do
comply
not
with
have
the order,
information. Because if they extend it also and I do not receive it, I will not have the
Learned AG has
information
already
it
said that he
been-
has got other alternative remedy if we are not extending, my lord. So he can take that alternative remedy, my lord. It's not
No,
extended.
because if the alternative,
the order is
I'm
there.
only
Lordship,
asking
the
a
order is
copy
there,
of
my
the
lord. Order
extended
is clear.
The order is there, and
Lordship.
on next date fix, he will definitely he'll produce that such copy if required.
Yes, Lord.
Item number 6.
22nd, and she was examined by the doctors, and the doctors has opined, because the court has asked one very important question to the doctors, that it may be out of place to request the Nigrim authorities to also give their opinion as to whether the accused could be treated at any other hospital other than Nigrim's for the purpose of removing the cell implant on her left hand. And Doctor of Nigrim has given the report as saying that the opinion given.
I think that should come from Mr. Shulai. You have the report with you?
Yes, I have. Let him complete. Lordship, since he is having access to all this document.
No, because the son has gone to the Nigrim with the mother, and the doctor said, after giving the prescriptions, doctor said, moreover, the primary surgeons will be more aware with the type of implant that he used. That is the finding of the doctor, he said. Nigrim said, will not take the risk, but the primary surgeon will be more aware about the type of implant done. That is the opinion given by the doctors.
This is your Lordship. Lordship, in fact, as per the medical report, your Lordship, it says the implant is in good condition, your Lordship.
Where's the report?
Your Lordship, I do have with me. I have flag mark, your Lordship. The condition of the accused is not so serious, your Lordship, as advanced, your Lordship, during the course of submission.
A person who is suffering from the sickness knows. We do not know that how the person is suffering in the jail.
Where is the?
Lordship, that person I have flag mark, your Lordship.
There are so many flags here.
Yes, your Lordship, because the flag mark are very important, your
Where is
Lordship.
the opinion of the?
Lordship, the first flag mark. Lordship, can you see that implant is good?
No, implant is in good position. That is, you see, that is relative. It could be good condition, could be bad condition, but the fact is that what we are considering here is the fact that the implant is required to be removed. Whether it should be removed, whether in Nigrim's or elsewhere, because the doctor has opined that it could have been removed by the primary surgeon, which means that at the place where the implant was inserted. That is
Value Hospital.
Otherwise, she doesn't have any. She doesn't have any sickness. Only minor, your Lordship, because of change of weather.
Because of the severe pain. She's
Seasonal change, your Lordship. That is the report.
That is a different thing.
what is the stage of evidence, isn't it?
Is a source of evidence.
How many witnesses have been examined?
Lordship, in this case, in the first case, only 2 witnesses examined out of 9, and in one case, 1 witness examined out of 12.
I'll allow her to go on interim bail, but she has to report immediately after the.
Lordship, let this bail application be kept pending, your Lordship. And then let her file the medical report before this honorable court. Let this bail application, if Lordship is inclined to grant interim bail, then let this bail application be kept pending, your Lordship, and the accused on the next day should file the medical.
That you can that can be done. So
It may not be as the honorable Supreme Court has done to Satyendra Kumar J, your Lordship.
Lordship, in this case,
allowed for medical treatment, but keep the bail application pending with a direction to submit the medical on the next day, your Lordship.
That can also be done.
Lordship, in this case, suppose if the medical doctor says that we need some more tests, it cannot be done.
Then you can file an application.
Yes, your Lordship.
That is
You can file an application.
Let's see, your Lordship, the bona fide of the accused, your Lordship.
No, but the doctor's opinion is also necessary, because if this person is suffering from the anyway, that is up to the court.
1 month's time will be given to you. Within that 1 month's time, hopefully the operation would be completed.
At least 2 months.
Why 2 months? 2 months should not take time.
It's only a remove the plate, Your Lordship.
In fact, if you consider it, of course, we are not medical expert, but
But just the doctor will do the report.
see, a fortnight would be good enough. 2 weeks is good enough.
It may create some complication also. I do not know. I'm not doctors.
See, the opinion is very much there that the implant is in good position, which means that there is no complication.
There is no
attached.
complication.
No complication attached, except that you require it to be removed. That's all. And that has, you see, there are many cases where on removal of an implant, nobody has died.
Yes. But sometimes very minor accident, minor operation also person dies.
I have a cousin who had a similar implant, more severe than this.
Yes.
He had a car accident or bike accident.
Like in many cases.
Nothing happened.
Of the court, Your Lordship.
Angiography.
Of the court, Your Lordship. My mother, she has been operated, and the plate is still here in the thigh, Your Lordship. She's fine. She has no complication. She has no grievance.
It depends the client.
That also
the patient to patient.
That also is 85 years old lady, Your Lordship.
It depends the patient to patient.
There are many cases where, once an implant is there in the arms or elsewhere, doctors would advise that you should not take it off for your entire life. So, anyway.
Then let this bill application be kept pending, Your Lordship. With the direction to the accused.
We can do that.
Yes.
To
2 months.
file
also, at least 2 months.
the medical
because the person has to go to Switzerland.
the report. 2 months is
You go, 1 month is good enough for you. I'm releasing you to on bail today. Within 1 month. Heard Mr. Kursi, learned counsel for the petitioner. Also heard Mr. Andy Shulai, learned AG. This court by order dated 20/12/2023 has directed that the accused person, Srimati Kim Nicole Kongsai, be produced before the concerned department at the Negrims, I full form to most for a medical checkup and thereafter for a report or opinion of the relevant doctor to be produced before this court. In compliance with the said order, the procedure was it complies with the said accused person had visited the Negrims and a medical report has been submitted before this court. Submitted for this court. Mr. Adi Leonard AG has submitted that on perusal of this said report, including the opinion of the doctor who has treated the patient, accused, more particularly with regard to the implant on her, is it left arm or
Left arm, Your Lordship.
left arm? What has been opined is that the implant is in good position. However, it is also the opinion of the doctor that the primary surgeon, meaning the surgeon who had carried out the operation when the implant was inserted on the victim, on the patient, oblique accused would be more aware as to the nature or the manner or the procedure adopted when such implant was inserted. Mr. Kursi has, Mr. Kursi, the learned counsel for the petitioner, in his submission has submitted that in his submission has relied upon the said opinion of the doctors at Negrims to say that it would be fit and proper for the operation, that is for removal of the implant, to be done at the place where the same was inserted, that is at Valley Hospital, Silchar, Assam. This court has considered the submission made and has also produced the said medical report. To the limited extent indicated herein, this court hereby directs that the accused person above named be released on interim bail to allow her to get the said implant removed at the place of her choice, that is Valley Hospital, Silchar, Assam. However, the whole procedure should not take more than 30 days from the date of this order, upon which she has to report before the prison authorities at the district prison.
Lordship, I could not get your lordship.
No, she has to report to the, we don't call it jail nowadays.
Yes,
District prison, isn't it? District prison and correctional home.
And correctional home.
Joy.
Joy.
On. Another Tasum?
Today is 28, your lordship. Then on 29.
On 29 January 2024 with relevant medical report.
It will be from the date of release only. Because I have to furnish the securities also.
Okay, let's put it this way. Another Arpanda 29 1st February.
1st February.
I know, 1st February. Huh?
See, if the no date is mentioned from the date of release, within 1 month from the date of release, because I have to furnish the securities also.
That would give you enough time. Well, you see, it will be better to keep.
Once the order of this code is furnished before the trial court will.
Lastly, the interim bail is hereby granted on the following condition: that the accused shall not abscond or tamper with the evidence. I key condition, you know. Same condition, nothing else. Any extra condition?
Lordship, only because this bail application will be kept pending, Your Lordship. Let this bail application be kept pending.
Lordship, the matter will be
and
sent to
then,
the trial
and then
court.
the medical report be furnished, Your Lordship.
Let
Let's
us
see the bona fide, Your Lordship.
No, the trial court may look into the matter, Lordship.
Lordship,
If the court directs the trial court will look into the matter.
You can file it here also, doesn't matter.
Yes, yes.
Eventually the petition will dispose of. Next, let the said report be. Let the said compliance report be filed.
By the accused, Your Lordship.
Let the said compliance and medical report be placed before this court within the next date fixed.
Lordship.
Place this matter on.
On third, Your Lordship.
Third is what? Third is, sir?
See, please check it. Let it be on 5th, Your Lordship, Monday. It's a Monday on 5-2 Monday.
5-2.
Lordship. Oblige, Your Lordship. Same order in the next item, Your Lordship.
Same order.
But only a different case number, Your Lordship.
Fine.
Because there are two cases, one is 64, one is 65. The first case is 64, special NDPS number 9. Then the second case is special NDPS 11, and cleared PS case number 65.
Yes.
I'll take back, Your Lordship, those medical, all the part of the record.
But they are part of the record. Why would you take it back? You're supposed to produce it today.
Apply, Your Lordship.
Second call, item number 6.